Hello, Dr. Hunter. This is Matthew Keogh, doing my video presentation for Equitable Remedies. And I had wrote a script for this, so this is probably only the second time I've ever done a YouTube video. So please bear with me. So part one of the legal and equitable remedies. There are two types of solutions available in Arizona when someone sues another person for harm caused. It's important to know the difference to choose the right one for each situation. First, legal remedies. These involve money given to the person harmed to make up for what they lost. For example, if someone's property is damaged, they might get money to repair it. Legal remedies include compensatory damages to cover losses, punitive damages to punish bad behavior, and nominal damages, small amounts when no big loss has happened. Equitable remedies, these are the actions rather than money. They're used to fix a problem or stop something bad from happening. For instance, a court might order someone to stop polluting a river, which is an injunction, or do what they promised in the contract, which is specific performance. Equitable remedies like rescission, canceling a contract, or reformation, fixing a contract's mistakes, are used when the wrong can't be fixed with money alone. Equitable remedies are decided by fairness and what's right for each case, not just following rules. Unlike legal remedies that are automatic, if you prove your case, equitable ones need proof. The money alone won't fix the problem. Understanding these differences helps people in Arizona know how to ask for help in the court, depending on what happened to them. My references for that specific topic, part one was the Arizona Judicial Branch under legal equitable remedies. Part two, the origin. The origins are in England. Equitable remedies started in medieval England because the regular courts couldn't always solve complex problems with just money. They couldn't fix everything fairly. So equity courts like Court of Chancery were created. These courts focused fairness and preventing unfairness. They developed guiding principles called maxims of equity to make sure everyone got a fair deal. These principles said things like equity won't let a wrong happen without solution. And if you want fairness, you must be fair. Equity in America, when America was formed, it took English law and these equity principles. Early American courts saw equity as important for solving tough cases that money alone couldn't fix. Over time, equity and regular law merged into one system, letting people use both types of remedies in court cases. Today's equitable remedies in modern Arizona, equitable remedies are still important. They help solve complicated disputes and make sure everyone gets a fair outcome. While laws and rules decide when and how these remedies can be used, courts have the power to choose the best way to solve each case fairly. Equity in tort cases. In tort cases where someone sues for harm, equitable remedies work alongside legal ones. For example, if someone is causing ongoing harm, a court might order them to stop, which is an injunction. Or if someone promised to do something and didn't, the court might make them do it, specific performance. These remedies help when just paying money isn't enough to fix the problem. Understanding this history helps lawyers and judges in Arizona use equitable remedies to make sure everyone gets treated fairly in cases. My reference for part two is the Grand Canyon University Library, Equitable Remedies, Histories and Principles. Part three, equitable remedies in Arizona offer various ways for people in tort cases to seek assistance beyond monetary compensation. Here are some simplified examples. One, injunctions. These are court orders that direct someone to either stop doing something like building a fence on your land or start doing something specific like halting, excuse me, like halting a competitor from using stolen business secrets. Specific performance. This occurs when court compete, compels someone to fulfill exactly what they promised in a contract. While more common in contracts, it can also apply in tort cases. For instance, someone has agreed to buy a rare, unique antique, but backed out. The court might enforce the purchase anyways. Rescission. This involves canceling a contract or deal and reverting to the situation before it happened. It is used when someone was misled into making an agreement, such as buying a car with false mileage information. Accounting. This entails the examination of financial transactions to uncover any improper gains or losses due to wrongful conduct. It often is used in cases involving breach of fiduciary duties or misappropriation of funds. Declaratory relief. This is when the court decides who is legally correct about an issue without awarding money or other remedies. For example, a dispute over property rights. The court can clarify who has the legal right to use a path between two properties. Excuse me. These examples illustrate how Arizona courts utilize equitable remedies to resolve legal disputes fairly and effectively in tort cases. My reference again was the Grand Canyon University Library under equitable remedies for examples and uses. Part 4. Equitable remedies are essential in Arizona courts, providing ways to solve legal problems fairly. Here are two important cases where these remedies were used. The City of Phoenix versus Superior Court, Tovar. The case overview. In the case from 1998, the Supreme Court dealt with environmental issues. The City of Phoenix asked for an injunction against Tovar, who polluted groundwater with dangerous chemicals. The application of equitable remedy, the court granted the injunction, ordering Tovar to clean up the contamination and protect public health. This shows how injunctions help enforce environmental laws. McLaughlin versus the City of Tucson, case overview. In 2002, the Arizona Court of Appeals heard a case about land use. McLaughlin wanted to build a commercial building but was denied a permit by Tucson based on a mistake about zoning rules. The application of equitable remedy. The court said Tucson had to give McLaughlin his permit because he should not lose his investment over Tucson's error. This shows specific performance can fix problems when money alone isn't enough. These cases demonstrate how Arizona courts use equitable remedies to make sure legal decisions are fair and just. I used three scholarly articles to help me with these. One was just to confirm the other. The Arizona Court of Appeals, McLaughlin versus City of Tucson, and the Arizona Supreme Court, City of Phoenix versus Supreme Court of Tovar, and the University of Arizona, cases applying equitable remedies in Arizona. In conclusion, these cases show that how Arizona courts use special solutions like injunctions and specific performance to solve different legal problems fairly. By using these types of remedies, courts make sure everyone gets treated fairly and justice is served properly. Learning about legal and equitable remedies in Arizona has shown how the law tries to make things fair when someone gets hurt or wronged. Legal remedies legal remedies give money to make up for losses, like when someone has to pay for damage they cause. Equitable remedies are different because they focus on fixing the problem itself, not just paying for it. They might make someone stop doing something wrong, like polluting a river, or do something they promised, like finishing to build a house. Studying the history of these remedies helped us see, helped me see where these ideas come from and how they've changed over time. They started in England a long time ago because regular courts couldn't always fix everything fairly. Now in Arizona, courts can use both legal and equitable remedies to make sure everyone is treated fairly in court. Looking at real cases in Arizona, like those involved in the city of Phoenix and the city of Tucson, showed us just how those remedies work in practice. In those court cases, the injunctions and specific performance to solve problems that money alone couldn't fix. These examples help us understand how important it is to have these options in our legal system and make sure justice is served. I appreciate you listening to my video. I hope this is up to your standards, Professor Hunter, and thank you for all you've done for me and to help me learn civil law over the last 2 months in this course. I've truly enjoyed it. Thank you, ma'am, very much. Bye.